It is 6:14 a.m. You're barefoot in your kitchen. The coffee hasn't finished brewing. Your kids are still asleep. And then you hear it. 3 hard knocks that don't sound like a neighbor. Bang, bang, bang. You freeze because your body recognizes the sound before your brain does. You walk to the door. You look through the peephole. 2 officers, dark jackets, big block letters, ICE. One of them is already reaching toward the handle like he expects it to open. They knock again, louder. Open the door. We need to talk to you. This is the moment where people lose everything in under 60 seconds. Not because they're guilty, not because they're bad, not because they deserve it. They lose because they do one thing the system is built to provoke. They open the door, they answer one question, or they sign one paper. Without understanding, they just waived the only leverage they had. Stay with me, because by the end of this video, you will know the exact 3 words that can protect you in that moment, and the 2 things you must never do, no matter how calm, polite, or friendly the officers sound. And later, I'm going to expose the single most common lie people tell themselves during an ICE encounter, the lie that makes them cooperate their way into detention. This is Immigration News Desk, and today is not a politics video. This is a survival briefing, because the system you're dealing with is not designed to educate you. It's designed to process you, fast, quietly, efficiently. And if you don't know the rules of the game, you become the easiest kind of target, compliant. Here's why this is happening more often, and why it feels like it's accelerating. Immigration enforcement in the United States has always expanded in cycles. Political pressure rises, budgets increase, new task forces are launched, and then normal families feel the impact on ordinary mornings. Over the last few decades, enforcement strategy shifted from border-only to interior enforcement through databases, local cooperation, and targeted operations. The public usually sees the spectacle: raids, buses, headlines. What you don't see is the machine underneath: information sharing, address trails, traffic stops, courthouse encounters, and paperwork traps that turn a conversation into a case. And here's the open loop you need to hold in your mind as we go. Most ICE encounters don't begin with violence. They begin with a friendly voice and a piece of paper. That's the trap. And in a few minutes, I'm going to show you how to tell whether that paper actually gives them power, or whether it's a psychological weapon designed to make you surrender your rights voluntarily. Let's talk about the friendly voice trap first, because this is where 90% of people collapse. The officer doesn't always come in shouting. Sometimes the tone is calm, polite, almost human. We're just here to ask a few questions. We're looking for someone named Carlos Martinez. Is that you? We just need to clear something up. It sounds harmless. It sounds like cooperation will end the discomfort faster. But that's not how this game works. In enforcement interviews, your words are not conversation. Your words are evidence, and the system is designed to convert your instinct to be polite into admissions it can use against you. If you answer, "Yes, that's me," you've just done their first job for them, identity confirmation. If you answer, "He's not here, but I know him," you've just created a link. If you answer questions about where you were born, when you entered, where you work, who lives with you, you are building the narrative they need. The officers are trained for this. You're not. Their calm tone is not kindness. It's a tactic. Now let's open the second loop, the one that's going to save you from the most expensive mistake. The word warrant is the most abused word in these encounters. They will say it like it's a magic spell. "We have a warrant," and your brain, trained by TV, thinks warrant equals judge, judge equals authority, authority equals I have to open the door. Wrong. There are 2 types of warrants that show up in immigration enforcement. Only one gives ICE the legal right to enter your home without your permission. A judicial warrant is signed by a judge, a real judge, from a court. It typically lists a specific address, a name, and authorizes entry or arrest under judicial authority. If they have that, your situation changes. You still have rights, powerful rights, but the entry question becomes different. An administrative warrant, often called an ICE warrant, is not signed by a judge. It is issued within the immigration enforcement apparatus, signed by an immigration officer or supervisor. It may look official, it may have seals, it may have formal language, but it does not carry the same constitutional weight for entering your home without consent. And this distinction exists for a reason. The Fourth Amendment is supposed to protect your home from government entry without judicial oversight. This is not a loophole. This is the architecture of American law. Your home has historically been treated as the most protected space, and enforcement agencies have always tried to bypass that protection with consent, fear, or confusion. That's why they lean so hard on the word warrant. They're betting you won't ask the next question. Here is the next question, the question that determines whether you keep control of the threshold. Do you have a warrant signed by a judge? Say it through the door, say it through a window, say it calmly, and do not open the door to ask it, because the doorway is not just wood and hinges, it's a legal boundary. The moment you open it, even a little, you create opportunities. They can claim you invited them in, they can see inside and claim exigent circumstances, they can wedge a foot, they can escalate. Now I'm going to give you a critical revelation that most people don't learn until it's too late. Officers do not need to win a legal argument on your porch. They just need you to consent. Consent is the shortcut around the Constitution. If you open the door and step back, if you say, "Okay, come in," if you let them inside just to talk, you've given them what they wanted without them proving anything. This is why the system is so dangerous to ordinary people. It's not that the Constitution vanished. It's that enforcement has evolved into asymmetric warfare. They know the rules, you don't. They know how to create consent, you don't know how to withhold it. Now let's talk about trap number 3, the paperwork pressure. If they detain you, whether on the street, at your home, during a traffic stop, or after an appointment, they may put papers in front of you and say something that sounds harmless. Just sign here and this will be over faster. This is just for processing. This is just acknowledging you were contacted. Listen to me carefully. In immigration enforcement, paperwork is not paperwork. It is a decision. Some forms are effectively you agreeing to leave, agreeing not to fight, agreeing you understand allegations, agreeing to a voluntary outcome that becomes very hard to undo. This is where people lose their case without ever seeing a judge. They sign because they're scared. They sign because they're exhausted. They sign because they think they're being cooperative. They sign because the officer implies signing is the smart way to avoid detention. And sometimes that implication is precisely the trap. You sign away your right to contest removal, and the system moves you faster, out. Hold this open loop. In a moment, I'm going to tell you exactly what to say when someone puts a form in front of you, and why "I didn't understand" won't protect you after you sign. But first you need to understand the legal shields you already have, because you do have them, regardless of your status. Here is the part the system does not advertise. The Constitution protects persons on U.S. soil, not just citizens, not just people with papers, persons. That includes you. The debate is always about how those rights are applied in specific contexts, but the baseline is real. You have protections. Shield 1 is the Fourth Amendment. It's the protection against unreasonable searches and seizures. Translated into real life, officers generally cannot enter your home without a judicial warrant or your consent. That, or your consent clause, is where your power lives. If you do not consent, you force them to prove authority. You force them to show a judge's signature. You force them to do it the hard way. Shield 2 is the Fifth Amendment, the right to remain silent. You do not have to answer questions about where you were born, how you entered, your immigration status, or who else lives in the house. Silence is not a crime. Silence is not an admission. Silence is your shield against self-incrimination and against building their narrative for them. Shield 3 is your right to counsel, your right to speak to a lawyer before answering questions or signing anything. Immigration proceedings are civil in nature, and the government does not always provide an attorney the way it does in criminal cases. But you still have the right to consult one, and you should invoke that right early, not after you've already talked yourself into a corner. Now, I'm going to give you the simple action plan. Not a speech, not a philosophy. A plan you can memorize and teach your family tonight. because knowledge is only useful if it survives adrenaline. Step 1. Do not open the door. Period. Talk through the door. Talk through a window. Ask them to slide any documents under the door or hold them up to the window, but keep the door closed. Most disasters begin with one polite opening. Step 2. Ask the threshold question. Do you have a warrant signed by a judge? If they say yes, ask them to show it. If they show you a paper, look for a judge's name and signature and the correct address. If it's not a judge, if it's an immigration officer's signature, that is not the same thing. And you say the sentence that preserves your boundary, I do not consent to you entering my home. Say it calmly. Say it once. Repeat it if needed. Do not argue. Do not lecture. Your goal is not to win a debate. Your goal is to withhold consent. Step 3. The 3 words. This is what you say when they start asking questions. Through the door, on the porch, on the street, anywhere. I remain silent. 3 words. Clean. Unemotional. Repeatable under stress. If you want the expanded version, it's even stronger. I am exercising my right to remain silent. I want a lawyer. But the 3-word version is easier to remember when your hands are shaking. Step 4. Do not run, do not resist physically, and do not lie. This is not about surrender. This is about not adding new problems. Running escalates. Resisting creates charges. Giving a fake name can create criminal exposure depending on circumstances. You want to keep your situation in the immigration lane, not compound it with additional allegations. Step 5. Do not sign anything without an attorney. If they put paperwork in front of you, your response is the same every time. I will not sign anything until I speak to my attorney. That sentence is your life raft. Not because it magically stops the process, but because it prevents you from voluntarily accelerating your own removal. Now let's close the paperwork loop with the clarity people need. The enforcement system loves voluntary outcomes because they're fast, cheap, and hard to appeal. If you sign away your right to a hearing, the machine can move you without resistance. That is why they pressure signatures. That is why they say it'll be faster. Faster for whom? Not for your family. Faster for the system. Now, there's a second scenario you need to be ready for. Not the home knock, but the street stop, bus stop, parking lot, outside your workplace, a traffic stop. This is where people panic because the home rules don't perfectly apply. Here is your first question in a public stop. Am I free to go? Ask it calmly. If they say yes, you leave calmly. Don't run, don't argue, don't keep talking. You walk away. The biggest mistake people make after hearing yes is they stay and keep explaining. Explaining creates evidence. Evidence creates leverage. If they say no, then you are being detained. Now your script activates. I remain silent. And if they push, you add, I do not consent to any searches. I want a lawyer. A quick reality check. In some states, there are laws requiring you to identify yourself to law enforcement under specific conditions. Immigration enforcement encounters can be complex, and local police involvement changes the terrain. This is exactly why you keep your statements minimal and why you get legal counsel if the situation escalates. The goal is not to play amateur lawyer on the sidewalk. The goal is to stop feeding the machine. Now I want to make this even more practical, because people watch videos like this and think, okay, but what do I actually do tonight? Tonight, you do 3 things. 1, you write down emergency numbers, not in your phone only, on paper, in your wallet, in your child's backpack if appropriate, a trusted family member, a reputable immigration attorney, a local legal aid organization. If you are detained, you may not have access to your phone the way you think you will. The system counts on that. 2, you create an emergency plan for your household. Who picks up the kids if you're not there? Who has a spare key? Where are the birth certificates, passports, medical records? Who has access to rent money? Who can contact your employer? This isn't paranoia. This is disaster preparedness in a bureaucratic environment. 3, you create a paper shield folder. Copies of any immigration documents you have, any court dates, any applications pending, any proof of long-term residence, family ties, medical needs. If you have lawful status, carry proof. If you're in a pending process, carry proof. If you have a prior order or complex history, consult counsel about what to carry and how to respond. Because the wrong document shown at the wrong time can create confusion. And confusion is how you get detained until they sort it out. Now let's talk about why this feels so predatory, because it's not just your imagination. Immigration enforcement is often conducted under civil authority, but the tactics borrow from criminal policing, surprise, pressure, speed, and psychological control. The goal is to create a moment where you comply before you think. That's why they arrive early. That's why they knock hard. That's why they speak quickly. That's why they use warrant language. They want you in reflex mode, not strategy mode. And now I'm going to reveal the lie I promised earlier. The lie people tell themselves that makes them cooperate their way into detention. If I'm polite and helpful, they'll go away. That is not how enforcement works. Politeness does not buy mercy. It buys efficiency. It helps them complete their task with less friction. You can be respectful without being cooperative. You can be calm without surrendering your rights. Respect is tone. Cooperation is evidence. Do not confuse them. Now another open loop you need to hear. Even people with lawful status can get trapped in this system if they don't know how to handle the moment. Mistaken identity happens. Database errors happen. Old removal orders under similar names happen. A prior arrest record that was dismissed can still trigger heightened scrutiny. And when the system makes a mistake, it does not apologize quickly. It detains first and corrects later. That is why you must treat every encounter like it matters, because it does. Let's go back to the door scenario and tighten the script, because if you remember nothing else, remember this. You do not open the door. You ask, "Do you have a warrant signed by a judge?" If they do not, you say, "I do not consent to you entering my home." If they ask questions, you say, "I remain silent." If they present papers, you say, "I will not sign anything until I speak to my attorney." That is the spine. Everything else is details. Now, what happens if they do have a judicial warrant? Here is the sober reality. You still do not have to answer questions. You still can remain silent. You still can ask for counsel. And you still should not sign anything without legal advice. A judicial warrant affects entry authority. It does not erase your Fifth Amendment rights. And if they enter anyway, even if you believe it's unlawful, you do not physically resist. You do not escalate. You preserve your body and your options. Unlawful entry is fought in court, not in the doorway. You win later by not creating new charges now. Now let's talk about the psychological weapon they use after detention. Speed. Once someone is in custody, the system moves fast. People think they'll have days to think. They might not. They might be transferred. They might be processed. They might be pressured to accept voluntary outcomes because the alternative, waiting in detention for a hearing, sounds terrifying. This is why legal support and community support are not optional luxuries. They are survival infrastructure. If you're a U.S. citizen or lawful permanent resident watching this for a loved one, here is what you do. You learn the script too. Because families get interrogated. Family members get pressured. Someone asks, "Is Carlos here?" And a spouse answers out of instinct. Someone asks, "What's his date of birth?" And a sibling answers because it feels harmless. It's not harmless. You are feeding the search. You can say, "I do not consent to a search." You can say, "I am not answering questions." You can say, "Please speak to my attorney." Those are not suspicious phrases. They are legal boundaries. Now I'm going to address a question I always get in comments. If I don't open the door, can they break it down? Generally, without a judicial warrant, they should not be entering your home without consent. But enforcement in the real world is messy. Officers sometimes push boundaries. Sometimes they rely on confusion. Sometimes they claim exigent circumstances. That's why you do everything calmly and clearly. You keep the door closed, you ask for a judge-signed warrant, you state non-consent out loud. You create a clear record of non-consent. If you end up needing legal defense later, that clarity matters. And here's another uncomfortable truth. The system is designed to make you feel isolated. It wants you to think you are alone, that nobody can help, that resistance is futile. That's psychological warfare. The antidote is preparation and community. Know who to call. Know your local legal resources. Know your emergency plan. And teach your household the script. Now I want to close with the 2 things you must never do. The 2 actions that cause irreversible damage. 1. Never open the door just because an officer says warrant, unless you have confirmed it is signed by a judge and authorizes entry to that address. If you open the door without verifying, you may have just handed them consent. That's not drama. That's how consent works legally. 2. Never sign anything in custody without speaking to an immigration attorney. Not because every document is a trap, but because one document can be, and you won't know which one under pressure. The system will always frame signing as faster. Faster is not the same as safer. If you remember nothing else, remember the 3 words, I remain silent. They are not rude. They are not aggressive. They are not anti-American. They are the Constitution working as designed for the person who knows how to invoke it. If this video helped you, don't treat it like content. Treat it like a tool. Send it to your family group chat. Send it to the friend who drives everyone to work. Send it to the cousin who just moved apartments and doesn't know the rules. Because the people who get hurt the most are not the ones who should have known better. They're the ones who never got told. We'll keep publishing practical, verified survival briefings like this at Immigration News Desk, because information is protection, and protection is how you keep families together in a system that is built to move faster than your understanding. Stay ready, stay calm, keep the door closed, and whatever you do, don't let a friendly voice talk you out of your rights.